David Kappos has just been, it's been announced that he's going to be nominated to be the next director of the US Patent and Trademark Office. Assuming that he gets through the nomination process unscathed, from an AIPLA perspective, what do you think are the major challenges that he faces, and what would you like to see him prioritising when he assumes his role?
Well, first of all, I think it's a very solid appointment, and I think we're looking forward to, we've been looking forward to that appointment for a while, and I think we're very pleased that it's come. The challenges are enormous, and that's one of the reasons why we're pleased it's finally arrived. The primary one, I think, is to reestablish the stakeholder relationship with the office. It's never probably been as polarized as it is now, and I think there are great opportunities for organizations like AIPLA and individual practitioners and inventors and others who practice for the office to reestablish themselves in many ways. I think the recent strains around the rule packages and around the pendency issues and the backlog, all of that needs to be dealt with very quickly. I think that one way to do that, frankly, is to have greater transparency and greater engagement with the stakeholder community. One of the reasons why it got to that point, I believe, is that there was a distancing that occurred, and that needs to be fixed. From AIPLA's perspective, I think the principal issues are the traditional ones: pendency and backlog, and quality. I think pendency and backlog probably more immediate now, particularly given the huge financial strains. I think that is probably the second big challenge facing the office and facing Dave, is how to deal with the financial hole that the office finds itself in, the shortfall that they're involved in. It's incredible, but because they base their budget on their projections of work, their budget actually went down by almost $100 million this year. So you've got a huge inventory, a smaller budget, and a declining revenue base. That makes for a bad combination. Are there opportunities? We could talk about fee increases, perhaps, but that's, I think, has to be premised on ending fee diversion permanently. And we're very watchful of what will happen in the Congress, and we hope this administration and certainly the Kappos team at USPTO supports that. Another big issue is getting the right leadership team in place. I don't know what changes may be planned, but I think this is part of the confidence building and capacity building that the office needs, and so we'll look very quickly to see who the deputy director is, and then who the senior leaders from the rest of the office that Dave appoints. I think another key issue on this backlog problem is there going to be internal reform changes. The Secretary of Commerce, Secretary Locke, has announced that he's making it a highest priority to make a significant reduction in pendency time, which is a great goal. I've even heard him quoted as a particular month-long period of time, which seems very ambitious. That will probably require substantial structural and rule changes. And to get those done, I think they need to bring in the stakeholders and work together to try to meet that goal, if that's indeed the direction it takes.
Okay. You mentioned Congress earlier on and fee diversion. That has been part of the patent reform package that's been going through Congress. Generally speaking, how do you see that process at the moment? How close do you think we are to actually getting legislation onto the statute books?
Well, I've sort of given up guessing since I've been wrong so many times, but being fairly close to that process and seeing how it's being played forward in Washington, I would guess the odds favor some types of reform in this Congress, which would be either this year or next. Now, that's conditioned on a number of things. We've got other more important matters, in some ways more important matters, such as the ending the recession and the Sotomayor nomination of the Supreme Court. But the Senate made a great head start on that by the compromise bill which they passed out of the Judiciary Committee. If the Senate as a whole can go along with that compromise, it would be great. The AIPLA supports that compromise completely. The opportunities in the House, I think, are similar. They've had a hearing already, which is a good start. And I think the need to find the right mix of reforms and the right compromises so that everybody's reasonably happy. No one's going to be completely happy. Everybody's not going to like some piece of it. But getting that right compromise together is important, and then making sure both houses can agree on it. A key issue will be, again, what the administration prioritizes. And will they weigh in on reform? Will David Kappos weigh in on reform? He's testified, interestingly enough, fairly recently, and it'll be an interesting question as to Whether those kinds of issues he testified on end up being the position of the administration or not, we'll have to see. But the Senate compromise is a great place to start.
Okay. And away from the what's going on in Congress and at the USPTO, how would you characterise the general IP landscape in the US currently? If you're an IP owner in the United States and you park the USPTO and patent reform to one side, what are the other issues that people are looking out for?
It's a kind of a schizophrenic time for IP in the United States. On the one hand, it's never been more important. Most of our major industries are very heavily reliant, some almost completely reliant on intellectual property for their asset base. On the other hand, they're facing skepticism around issues like how to enforce, are patents too strong, that sort of thing. And you're seeing a lot of that in the reform debate. Now, interestingly, a lot of that reform has come through the courts already, and we're starting to see what I think many people would think is right sizing, but others would think might be pendulum swinging back a little too far. We'll wait and see how that plays out. But you have this kind of schizophrenic nature of never more important and increasing skepticism. A key marker, I think, will be one we've mentioned. What are the administration positions on a number of these issues? The second big marker will be the Supreme Court and the actions they take in Bilski.
Okay, and Bilski is something I do want to touch on. First of all, do you expect the AIPLA to be filing an amicus brief in that case? And what do you see that is at stake in Bilski? Well,
first of all, as we sit here today, I don't want to get ahead of my board who makes the final decision, but we did file amicus briefs at the CAC, and I would anticipate that we'll very strongly consider that and probably very likely to file an amicus brief in Bilski. In some ways, the system may be at stake in Bilski. It's sort of one of the last major issues is what's patentable subject matter in the first place. And there's been so much of the reform, so many reform issues get focused on things like patentable subject matter, which in some ways I'm not sure is the right approach. If the quality, then we're talking about the quality of patents, which is the second key issue. Quality perhaps ought to be a function of things like disclosure and the notice requirement, which all are captured by 112, or what's obvious. Bilski concerns arguably a business method patent, and you hear a lot of, well, that was thought of years ago. Well, then that's an obviousness anticipation, 102, 103 issue. It's not a patentable subject matter issue. So I think one of the challenges for amicus like ours is likely to make sure we focus the court on the right set of issues, and not perhaps so much, to the extent we can, and not so much perhaps on patentable subject matter, which has traditionally been, in the United States, a broad issue. And we arguably have one of the greatest technology bases in the world. I don't think those two coexist by accident, and it would be, I think, unfortunate to cut back too far on 101 without a complete and thorough review of the system. I know that many people feel that the CAFC did not quite get it right in the standard they set on processes, and that the biotech community in particular doesn't think it fits their business model so well. There's a lot to that. I think that, however, that of the 12 judges in the en banc, 11 of them found it was not patentable subject matter for different reasons, but there were 11 of them, and that's a pretty strong base to start with.
Brilliant. Todd, thanks very much indeed.
Sure.
Thank you.